All four witnesses say it didn't happen. I'm known to have a weak stomach. Flatulence. Drinking game.
There are a lot of allegations floating around that Brett Kavanaugh committed perjury during that hearing. I think perjury is a lot more difficult to prove than people realize and is not actually the appropriate standard for analyzing this particular hearing. Criminal perjury is lying under oath, knowingly and intentionally, about a material matter. So to prove an actual criminal case of perjury that you would prosecute, you've got to be able to show, if you're the government, beyond a reasonable doubt that the defendant, knowingly lied, knew they were doing it, and that it was about something that mattered. And there's no room for, confusion, misunderstanding. Mistakes aren't perjury. Failures of recollection aren't perjury.
I liked beer, but I did not drink beer to the point of blacking out.
How would you come in and prove to a unanimous jury beyond reasonable doubt that he had in fact blacked out? Now you can bring in witnesses who will say, well, he drank a lot, he was a sloppy drunk. We think it's unlikely that he would remember everything the next day, but that's their opinion. If the guy who's been doing the drinking says, I never blacked out, how do you disprove that?
Devil's Triangle.
Drinking game.
I don't know if it's buffed or boofed.
That refers to flatulence. We were 16.
When there are claims about these yearbook statements that seem to be just flatly, implausible. Little lies about these yearbook references, adolescent, things are kind of silly and nobody would care. In the context of this hearing, they seem to take on some more significance. Now, again, would they ever actually be criminally prosecuted for perjury? Probably not.
I never attended a gathering like the one Dr. Ford describes in her allegation.
Like the one she described. Well, what does that mean? Does that mean one with the same people? Does that mean one at that precise house? Does that mean one where someone was assaulted? That's a good example of the kind of wiggle room that language can leave.
All four witnesses who are alleged to be at the event said it didn't happen. All four witnesses who are allegedly at the event have said it didn't happen. All four witnesses say it didn't happen.
I was surprised the senators didn't call him out on that. I think if you were, cross-examining a witness like that at trial, you'd stop them and say, no, look, Judge, that's not correct. They didn't say it didn't happen. They said they don't remember it, and sort of confront him with that, and nobody did. The Supreme Court has said the burden's on the questioner to make sure the witness is pinned down, there's no ambiguity, there's no wiggle room. That's hard to do even for a skilled trial attorney. So the question isn't really, the standard shouldn't be, could we prove a criminal perjury case? The question should be, is this a credible witness? And assessing their testimony overall, are they believable, are they credible? And if you think they're lying or misleading or being evasive about some things, then that suggests they might be lying or being misleading or being evasive about other things. That's a standard jury instruction that judges give all the time.